Hello and welcome back to the WHorld of Employment Law podcast. I'm Charlie, a paralegal in the Employment Law team, and I'm joined today by Kash, who is a senior associate. And we're going to be continuing the topics of different types of leave. And today we're going to be exploring two different types. So parental leave, otherwise known as ordinary parental leave, and also time off for dependents. So we're going to discuss how each type of leave can be used, the eligibility for each type of leave, and anything else that we think is relevant. We're also going to compare it to the leave that we spoke about in the last episode, which was carers leave, and how they vary from each other. So I'm going to hand you over to Kash, who's going to tell you a little bit about parental leave.
So parental leave, but not many employees may be aware of the contents of it. So we'll briefly just go over that. So it's essentially, it's an addition to your maternity leave, paternity leave, adoption leave. And it's usually used for when employees, namely, of course, parents, have the right to unpaid time off to look after their children. Now, like I said, not many employees are aware of the contents of it. It is usually unpaid, but some employers may decide to offer discretionary payments. But of course, that will be confirmed in any relevant policies that the employer has in place. Now, I'll hand back over to Charlie, and he can go through when parental leave may be used.
So we've put together a little list with the help of ACAS, which is a really helpful service for individuals to kind of understand more of their rights on this topic. We've put together a list of some examples of where this kind of leave would be really useful. So spending more time with children, quite a blanket phrase, and covers quite a large area. But that's something where it can be used. Time to look after them during the school holidays, where they don't have the childcare that they would have during term time. Looking after them when they're off school with illnesses or visiting grandparents or other relatives. It's quite a blanket type of leave, but we think those are a couple of good examples where it comes in really handy. And in terms of eligibility for parental leave, again, a little bit wider, but there are two main points. The individual must be legally classed as an employee, and they must have at least 1 year's service with the company. And they must also have parental responsibility for the child. So that's not just when they're a birth parent. It can be via adoption or surrogacy, or as well legal guardianship. And step parents can also have parental responsibility and therefore have the right to take parental leave when it's agreed between all of the parties. And there are certain restrictions about taking parental leave in terms of how long you can take and when you can take it. So Kash is going to talk you through that next.
Yes, so in accordance with the definition, a child is anyone under the age of 18. So any parent can take it, and they can take up to 18 weeks of parental leave for each child. And the way they take that is either in blocks of weeks, or they can be a maximum of 4 weeks a year for each child. Again, each employer may have different policies in place with a bit of movement around those. But from a legal standpoint, that's the way it is approached. It's also important to note that employees still accrue any annual leave during periods of parental leave that they are on. So, of course, employers also need to take that into account as well. And, of course, employees need to be aware of that. So their holiday entitlement will still accrue during any periods of parental leave that they do take. Now, in terms of giving notice for a parental leave, of course, again, this differs from employer to employer, but the absolute minimum an employee should give to their employer is 21 days notice before the date they want to start a block of parental leave, and of course, the exact dates that they plan to start and finish the block of parental leave. That just gives both parties, the employer and employee, just transparency. Of course, gives the employer a bit of notice, around 3 weeks' notice of an employee's intention to take that leave. And of course, any start and finish dates will also need to be communicated. Again, that will help the employer to see, okay, is it viable that the employee can take it around this time? And also an employer can plan around those dates as well, i.e. can they get someone in to cover the employee's shifts, or again, if it's a busy period, if they can't accommodate to that, maybe they can provide alternative dates. But like I said, legally speaking, 21 days notice is the minimum again, as before, employers may have different timescales in their policies. They may say 28 days, etc. But like I said, 21 days is the absolute minimum that they should give.
And in terms of whether or not an employer can say no or can change the proposed dates of leave, an employer cannot blank refuse or cancel parental leave. They can postpone it, however, and that's if it's going to cause issues at work. So, for example, if there's a big project deadline, they can postpone it for up to 6 months after the date that the individual asked for. But the employee must be able to take it before the child's 18th birthday. That's really important. And if the employer does need to postpone the parental leave, they have to write in writing to the employee within 7 days, and they have to explain why the leave has to be postponed, and they have to give some suggestions for other suitable dates. One other thing that is really important to highlight is that the rules differ slightly when you're trying to take parental leave for a child that's disabled. So as Kash mentioned earlier, ordinary parental leave has to be taken in blocks of a week, so you can't take the odd day. However, they can be taken when you have a disabled child. So an employee can take parental leave in blocks of days rather than weeks if they receive a disability living allowance or a personal independence payment for their child. That's something really important to highlight because it can be lost in all of the legislation. And just one other point on this, if an individual was wanting to take less than a week off to look after a child that's not disabled, they would have to use a different type of leave. So in an emergency or unexpected event, an employee might need 1 or 2 days to look after their child. And in these situations, they can use a couple of different types. They can use annual leave, otherwise known as holiday. They could use a special leave. So this is normally a leave that an employer has in a contract, might be unpaid, might be paid. And they can also use time off for dependents, which is handy because it's our next type of leave that we're going to talk about in this podcast. So once again, I'll hand over to Kash, who'll tell you a little bit about this leave and how it differs from parental leave.
So as Charlie said, it's an alternative type of leave, for example, when a parent may want less than a week off to look after a child. So time off for dependents, anyone legally classed as an employee can take time off to help a dependent with an emergency. Now, the key point to note is the definition of what a dependent actually is. So it's essentially a close family member or someone who depends on you. So the most notable ones would, of course, be a husband, wife, civil partner or partner. It can be a child, a parent, someone who lives in the household. Note that they can't be tenants, lodgers or employees. And, of course, someone who relies on them, such as maybe an elderly neighbour. They could all fall within the definition of dependents. Now, in terms of how much time someone can take off for dependents, I know Charlie mentioned just previously that it can be the odd day here or there. The law states for time off for dependents leave, it doesn't actually stipulate the amount of time an employee can take off. Because each emergency essentially is going to be different, it just states that the amount needs to be reasonable. So employers can use their discretion and flexibility in determining what is reasonable. Again, so for example, I don't know if it's a death that's happened in someone's family, and of course they're a dependent. You may want to consider taking into account, of course, the funeral arrangements, of course, or likewise, if someone's, a child's fell sick, you may need to take a few days here and there. So it really does depend on the circumstances as to why the leave needs to be taken, and going from that, then an employer can establish, okay, what amount of time is reasonable. When to take this leave, I will hand over to Charlie, and he can go through some examples of when we would typically expect employees to take dependents leave.
Yeah, so we're really conscious that this sounds an awful lot like carers leave, which is what Adam and Tina spoke about in the last podcast. So I thought it would be really important just to compare the two and explain how they differ. So as Kash has mentioned, the crux of time off for dependents leave is when it is an unexpected problem or an emergency. So for example, you're helping a dependent who's ill, you're taking a dependent to hospital, or when they go into labour, for example, or when a child's school unexpectedly closes, or as Kash mentioned, there's a death of a dependent. which then may fall slightly into bereavement leave. However, this type of leave is when there is an unexpected problem or an emergency. When you're aware about a situation beforehand, so for example, a pre-booked hospital appointment, time off for dependence leave can't be taken. That is where it falls into carers leave, which again, you're entitled to 1 week of unpaid carers leave in every 12-month period. Time off for dependents, there is no cap. It's just the amount that should be reasonable for each given situation. So the crux, time off for dependents, unexpected issues, carers leave, pre-planned. That's the most important difference between the two. And in terms of pay, it's the same again. So time off for dependents does not have to be paid. There is no statutory right to be paid for this type of leave, as with carers leave, but it is up to an employer. And individuals should check each individual policy, which should state whether they'll be paid or not. And from an employer's perspective, it's really important that you apply this consistently. You can't pay one person, not pay another person, pay someone for one issue, not pay someone for another issue. It has to be really consistent, or you leave yourself at risk of claims of discrimination in an employment tribunal. So just to recap, time off for dependents for an unexpected problem or emergency, and there is no cap on how much leave you can take. It has to be reasonable, and it's an unpaid statutory right. Again, employers can pay, but they don't have to. So I thought it would be really useful to take you through these two types of leave in this podcast. I know we've got some more podcasts planned to go through different types of parental leave, so maternity, paternity leave. That's coming up next month. We just thought we'd take you through these two types of leave because we're really conscious that there's a lot of different types of leave that can be taken, and it can be quite difficult to get your head around them. So we hope this has helped you. And if you have any questions, please do get in touch with a member of the team and we'd be happy to assist you further.